Before we begin, I'd like to acknowledge that we meet tonight on the traditional land of the Wurundjeri people of the Greater Kulin Nation. I wish to acknowledge them as the traditional owners of this land and to pay my respects to their elders, past and present, and to elders from other communities who may be here today. To our guest speaker, Judge Hampel, Associate Justice Diakonu, the President of the Australian Bar Association, Mr William Ulstergren QC, representatives of the Victorian Bar, the Law Institute of Victoria, and the Tristan Jepson Memorial Foundation, ladies and gentlemen. Welcome to the 2017 Tristan Jepson Memorial Foundation Melbourne Lecture. My name is Philippa Coccioloni, and I am 1/3 of the Tristan Jepson Melbourne Working Group, together with Arundhati Jayakode and Max Patterson. While I have the microphone, I'd like to say a few thank yous on behalf of the Working Group. First of all, to our sponsors, DLA Piper, for accommodating us tonight, in particular to Managing Partner Melinda Upton, who made all of this possible, and also to Tamsin Deschalaine, who has been integral in tonight's logistics. I don't think Tamsin said no to me once in the last 3 months, so thank you very much. Thank you also to our sponsor, the Legal Services Board, who have put on the lovely food and drink that you'll get to enjoy after tonight's lecture. Next, I'd like to thank our signatories, not just for humouring me for the last few weeks, but also for your ongoing support and commitment to implementing the Tristan Jepson Memorial Foundation's guidelines. Your ongoing support takes the Foundation's work from the abstract to the concrete by creating positive change to our working conditions. And it's wonderful to see so many of you here tonight. Finally, I'd like to thank Murray Jepson, who is co-founder and director of the Tristan Jepson Memorial Foundation. The profession owes you a huge debt of gratitude for choosing to honour your son's memory by making our experience of work and our experience of life a better experience. Finally, on your chairs, you'll find a flyer for the support group Pleading Sanity. We ask that you take that flyer home with you and take it to your organisations and help us promote this really wonderful support group that is run in conjunction with the Foundation. So it's more than enough from me. It's my pleasure to now introduce William Ulstergren QC, who will commence proceedings.
Your Honours, distinguished guests, ladies and gentlemen, can I say on behalf of the Australian Bar Association and each of the independent bars around Australia how incredibly important this foundation and indeed this cause is. I think by the extraordinary presence tonight of so many people from various parts of the profession, it demonstrates the importance and the very great challenges that face our profession, perhaps because of the very nature of lawyers themselves, but also because of the awareness which this foundation has caused to be raised. It's my great pleasure to introduce Her Honour Judge Felicity Hampel SC. I have the great pleasure of introducing her because I've known her for so very long. It doesn't mean that she's old, it probably means I'm old. But can I indicate that George and Felicity Hampel have both been such incredible contributors to the independent bars and particularly to the Victorian Bar for so many years. I'm delighted that the Honourable Professor George Hampel, of course, is here tonight, and I've nicknamed him the judicial handbag for the first time in his life. George has been a great contributor, but can I say in her own right, Judge Felicity Hampel has been an extraordinary leader to our profession. I say that not only because of her extraordinary work on the county court itself and through the project that she's in fact initiated, but also the amount of people she's mentored through the profession. I know this from the fact of even in my readers course that I saw firsthand the way she mentored one of our co-readers and so many other people, whether it be at the bar, having a coffee, just discussing problems that they may be facing or even on the ski slopes. Felicity has been a great friend and a great example to all of us. She commenced practice as a barrister in 1981 and was appropriately appointed Silk in 1996. She became a County Court judge in 2005. She's an adjunct professor at the Faculty of Law at Monash University, a Fellow of the Australian Academy of Law, Vice Chair of the Board of the Australian Advocacy Institute, and a Trustee of the Alan Misson Trust. Her past positions demonstrate her great contribution to our profession, including being a part-time Commissioner of the Victorian Law Reform Commission, President of Liberty Victoria, a board member of the Royal Women's Hospital and Trinity College, a member of the advisory boards of the Caston Centre for Human Rights and the Institute of Legal Studies at the Australian Catholic University. She was also a member, or is a member, of the Bill Kent Foundation Fund Advisory Board. She was a founding member of the Australian Women's Lawyers and Women's Bar Association, Vice Chair of the Victorian Bar Readers Course Committee, and a member of the Victorian Bar Equity before the Law Committee. She did all this whilst having a stellar career at the bar and was one of our most respected trial advocates before we lost her to the bench. As I said, she was a major contributor to the bar, an incredibly well-respected barrister and, of course, a judge. Ladies and gentlemen, Judge Felicity Hampel.
Thank you, Will. That was a lovely and generous introduction. The County Court is the major trial court in Victoria. We hear all serious crime except murder and treason. We deal with other cases involving unlawful killings, causing death by driving or workplace negligence. We deal with the consequences of unlawfully injuring someone, whether by driving, workplace negligence, or assault. Some people can make a complete recovery from their injuries. At the other end of the scale, we see people who've suffered catastrophic head injury, who've been left paraplegic, who've lost limbs, are left with disfiguring scarring or debilitating internal injuries. We deal with major drug importations, large-scale drug trafficking, clandestine laboratories and grow houses. Then there are the armed robberies. Some are sophisticated, well-planned operations involving the use of firearms, where significant amounts stand to be obtained from payrolls, safes of gaming venues or banks. Others are less well-planned, but often more terrifying for the victims, where often drug-impaired people armed with a syringe, a knife, a baseball bat, or a gun, which may or may not be real, and which may or may not be loaded, reap meagre gains from a service station, convenience store, or pharmacy. Then there are the aggravated burglaries, or run-throughs or home invasions. The major frauds, thefts, and deceptions committed with a pen, or these days more likely a computer keyboard, which enable fraudsters, accountants, and bookkeepers to steal money from under the noses of the people who've reposed their trust in them to assist in the management of their affairs. We see the ram raiders, the ATM skimmers, the extortionists and blackmailers, and those who defraud the revenue. And that's before we get to sexual offences, including child sexual offences and pornography and family violence. And by child sex offences, I'm speaking not only of those cases where the complainants are still children, and speaking of something in their recent past, but also cases where the complainants are now adults and are speaking of what happened to them as children. Where a person pleads not guilty, a trial is conducted before a judge and jury. So we hear the evidence presented to the jury in real time. Sometimes we hear it more than once. We, all of us in the County Court, know a lot more about sexual activity than most people in the community. We know things we don't want to know, but find hard to forget. If a person pleads guilty or is found guilty by a jury, we must sentence them. Just to give you a sense of the numbers, last year we heard over 300 trials and over 1,500 guilty pleas. Just under half, 44% of all trials were for sexual offences. By contrast, only 13% of the guilty pleas were for sexual offences. Sentencing involves an analysis of the factual foundation of the guilty plea or the verdict of guilty, consideration of the impact on the victim, and consideration of the personal circumstances of the offender. In most cases, we're provided with the victim impact statement. The victim impact statement sets out, sometimes in distressing detail, the impact of the offending on the victim. For some victims, particularly adults who were sexually abused as children, and the surviving families of people killed in motor vehicle or industrial accidents, the effects are profound and lifelong. We see cruelty, depravity, and brutality. We see families divided and lifelong friendships ruptured, mothers alienated from their children because they continue to support partners who have admitted abusing their children. We see parents consumed with guilt because they didn't know their child was being abused by someone they trusted. We see good people who had the misfortune to be in the wrong place at the wrong time, and good people who made a wrong decision or a mistake with devastating consequences for the victims and themselves. We see people who can forgive and people who can't. Some offenders come from a background of appalling disadvantage, neglect and deprivation. Others had every opportunity but haven't benefited from it. Some who carry the burden of their guilt forever, others who impress as being without remorse. Some look to have excellent prospects for rehabilitation. For others, the prospect of changing their ways seems bleak. Some are lucky enough to have family support, a home and a job to look forward to. Others have nothing and nobody. For the many who present with a history of substance abuse, we face the reality of disgracefully inadequate detox or long-term rehabilitation facilities, which may help them to become and remain substance-free. For the many who present with a history of mental illness or psychological disturbance, we face daily the reality of an overstretched and under-resourced mental health sector, which simply cannot meet the needs of all who could benefit from mental health services. Housing, or rather lack of it, is a perennial problem for people who come to be sentenced in our courts. Homelessness compounds all of the other problems that offenders face. For many of the people we come to sentence, the reality is, under our sentencing laws, there is no option but imprisonment. The combination of tighter restrictions on release on bail or release on parole has resulted in vastly increased prison populations and a vastly reduced cohort of people who can be subject to conditional release, involving supervision by way of parole or bail conditions. We know that supervision in the community encourages rehabilitation and reduces the risk of repeat offending. The opposite of that is equally obvious. Unsupervised or unconditional release is in itself a significant repeat offending factor. And that risk factor is compounded by the matters I've already identified: homelessness, lack of family and friends, no income, and no real access to alcohol or drug abuse-related services or mental health services. We also deal with people who are, by reason of mental illness or intellectual impairment, unfit to participate in a trial or to be held criminally responsible for their conduct. That involves making decisions about whether it is safe to release them into the community or whether they must be detained in a mental health facility or prison. Although the government has recently announced an expansion of the one secure mental health facility in the state, Thomas Embling, people who should be there are still being held in jails because there are simply not enough beds. And we must also decide whether people who, having completed a term of imprisonment for sexual offending, are at such risk of committing like offences that they are to be made subject to a supervision order and significant restrictions on their freedom in the community after their release. This is our daily reality. We know that in the context of a criminal trial and criminal sentencing, it is rare that everybody involved in the case will be happy with or accept the outcome. It's understandable that those directly involved will not be. Their lives will never be the same. Trials and sentences cannot right the wrongs that led to a person being charged or sentenced. And the hope that a trial or sentence will bring closure is often not realised. Such work takes a toll. If we acknowledge that we are human beings, you cannot help at times feeling repulsion, horror, dismay, anger, despair, distress. It can shake your faith in humanity, and it can feel unremitting. That's our criminal work. The single largest part of our civil work involves dealing with applications for compensation arising out of workplace or motor vehicle accidents. The daily fare for a judge in serious injury applications involves consideration of whether, and if so, to what extent, a person's life has been permanently changed for the worse by reason of a workplace or motor vehicle accident. And whilst consideration of commercial work does not normally provoke discussion about the personal toll on litigants or the court, we know many litigants in commercial cases face financial ruin if they're unsuccessful. They may have staked everything they own and they've worked to amass. Spouses, parents and others may have backed them and also stand to lose everything. Others risk significant reputational damage, harming their prospects for future employment in their chosen field if their conduct is found wanting or they're not believed on their oath. So it's not surprising, in addition to the well-known and documented risks to mental health and well-being that lawyers face, that those in the court system also face a real risk to their mental health and well-being as a result of stress and vicarious trauma. There has been until now limited research into vicarious trauma experienced by judges, court staff and criminal lawyers. Carley Schreiber, who's here tonight, lawyer, psychologist, Judicial College of Victoria Judicial Wellbeing Project Advisor and PhD candidate, is conducting an Australia First study into judicial wellbeing. When her research is concluded, we should be much better informed. Much of what I say tonight and much of my learning in this area has come from Carley, and I'm very much in her debt. Vicarious trauma can be defined as the consequence to a person of exposure to the traumatic experiences of others. Symptoms of vicarious trauma can include a profound loss of pleasure in life, whether work, home, family, or leisure, impairment of judgment and capacity to think clearly, over-reliance on coping mechanisms such as alcohol and other substances, isolation, intellectualising problems to protect against feelings and emotions, working harder so as to limit the time to think, seeing the world as unsafe, loss of trust in self and others, disturbed sleep, withdrawal from intimacy, depression, anxiety, compassion fatigue or burnout, decreased motivation, efficacy and empathy, and PTSD symptoms such as exhaustion, heightened arousal, avoidance, numbness to reminders of trauma, and re-experiencing of the traumatic events of victims. The most obvious, but by no means only cases which expose those in the court system to the risk of vicarious trauma are sexual offences involving children, with that expanded definition I gave you, including adults, speaking of what happened to them as children, and child pornography. Anecdotally, judges and others involved in the criminal justice system often speak of the added impact or distress caused by seeing an image of abuse of a child as opposed to hearing a person speak directly of it and the impact that has on them. Although the evidence is scant, what little we do know suggests that lawyers may experience higher rates of vicarious trauma than mental health workers and social workers and other first responders. High caseloads, lack of education about the effect of working with traumatised people, the absence of support, in particular, the absence of multidisciplinary teams and collaborative work practices, the need to be objective and impartial and to maintain and the absence of debriefing mechanisms built into court processes are all likely contributing factors. In the County Court, we have over recent years been talking more openly about the potentially harmful effect on judges and court staff of the nature of the work we do, particularly in the criminal jurisdiction and particularly in child sex offence cases. As the figures I gave you show, they account for a high and an increasingly high proportion of our workload. In the court, there has been a real culture change. Most judges, of course, come from a background where legal training and practice at the bar involved no exposure to, or for that matter, no respect for, the learnings from the social sciences about how this might affect us, not as lawyers, but as human beings. We prided ourselves on our ability to maintain objectivity, not to show our true feelings when exposed to deeply distressing material in court, and to be impartial. But the reality is you cannot keep on being exposed to material of this nature without being affected by it. And awareness of that has led to an awareness that exposure on a repeated basis to other people's traumatic experiences, not confined to child sexual offences, is likely to have a negative effect on our well-being. Given what we know now about the prevalence of child sexual abuse and family violence and its demographic spread, it's also something we must acknowledge that is statistically likely that some people exposed to these cases have themselves experienced sexual abuse or family violence. I'm very proud of the progress that the County Court has made in recognising and acknowledging this. We accept that we have a responsibility to judges and court staff to protect them from the risk of harm from repeated exposure to other people's traumatic experiences. We've taken significant steps to look after judges and court staff. We may be ahead of other courts, but I think we are in the very early stages of a voyage of discovery. Our initiatives include a judicial reflective practice program following a successful pilot to enhance the capacity of judges to manage stress and exposure to vicarious trauma by talking with a mental health professional in a manner akin to the clinical supervision provided by psychiatrists and psychologists to their colleagues. We have a peer support program for court staff, mandatory training for everybody who joins the court at induction and in continuing professional development in identifying and managing stress and vicarious trauma, a better directed judicial employee assistance program, regular on-site counselling, and a range of programs directed at enhancing physical and mental health and well-being. Whilst the Bar, the Office of Public Prosecutions, Victoria Legal Aid and the Law Institute of Victoria all offer some measures of support for the barristers and solicitors involved in court proceedings who are likely to be exposed to the risk of vicarious trauma, there's clearly more work to be done. There are some excellent initiatives, but it's fair to say that neither preventative nor crisis care programs are embedded in the cultures of these organisations. The reality of the risk of vicarious trauma, particularly for those practising in criminal law, and more particularly for those exposed to cases involving child sexual abuse, can no longer be ignored. No individual, employer, or briefing agency can justify waiting until a person is actually harmed as a result of exposure to the work that we do. They can't wait for then to think about what to do, what could have been done to avoid the risk, or to help that person, once they're suffering, manage better. Individuals, organisations and briefing agencies must identify the events or risk factors that can cause vicarious trauma to individuals or groups of individuals. Provide education or educate themselves about vicarious trauma and how to manage it. Actively look at ways of managing exposure and of building resilience. They must ensure that there are mechanisms for supervision and debriefing and the means to recognise vicarious trauma when it does manifest itself. And they must be ready to provide or access help with managing vicarious trauma. The information is all out there, easily discoverable and easy to implement. It just needs awareness and commitment. I want to turn now to the broader topic of what I described earlier as the well-known and documented risks to mental health and well-being that lawyers face. And here I'm talking of all lawyers, not just those exposed to the traumatic experience of others. Until recently, everything I had read and heard about this area suggested that lawyers are different, that law students, lawyers and judges experience stress, psychological distress, anxiety and depression at levels significantly higher than that experienced by students and practitioners in other professions or in the population at large. There's been much written and hypothesised about why that's so. Consideration has been given to personality types, the personality types who are attracted to the law and who make successful lawyers. Ever since I first heard that lawyers, particularly barristers and judges, had high levels of obsessive-compulsive tendencies, I felt liberated. I could accept that attention to detail, insistence on uniform procedures or routine, even that feeling of pleasure at seeing every page in the ring binder perfectly lined up, helped make me good at what I did, even if it made me very difficult otherwise. As lawyers, we're taught to question and challenge everything we're told. We're catastrophizers or pessimists. We need to think of the worst possible outcome and to prepare for it. Wearing my advocacy teaching hat, I'm constantly telling young lawyers to assume the worst when they're preparing a cross-examination, not to think that the witness will give them the answer most favourable to their interests. They should assume the opposite will happen. Because we represent the interests of others, we're dealing with the consequences of other people's behaviour. We're not responsible for the client's behaviour or the consequences, but we take on the responsibility for managing at least the legal consequences. That can lead to levels of emotional detachment, a sense of powerlessness, or even futility. The philosophical basis for an adversarial system appeals to fundamental notions of fairness, that he, she, or it who accuses must prove. But all too often, adversarialism is equated with aggression. They, and a winner-takes-all approach to competitiveness, are treated as interchangeable ideas. It's a mindset or culture which, in my view, has not only infected litigation, but has spilt over into other aspects of legal work and into legal practice. These factors, or some of them, have led, it seems to me, to a widespread acceptance that a combination of personality types attracted to or successful in the practice of the law, what is described as the inherent nature of the job, work practices which treat working long hours as something in itself to be valued, the way workplaces are organised, the criteria by which success and promotion are measured, and uncertainty about, or lack of security in employment, are all likely contributing factors to that heightened risk of depression, anxiety, and psychological distress seen and measured in law students and lawyers. It's tempting to accept this and say, we're different, for that read special. It's in our nature, or it's the nature of our work, which predisposes us to these high levels of anxiety and depression. We're like artists, treading a fine line between creative genius and madness. That is, to accept that this is just part of what goes with the job, particularly if we want to be successful. But I want to challenge that. The working hypothesis of the title of this talk, How to Be a Human Being and a Lawyer Too, is that the two are not mutually exclusive. I mentioned before my debt to Carley Schreiber. It was she who put me onto a paper by Professors Lawrence Krieger and Kenan Sheldon, What Makes Lawyers Happy? A Data-Driven Prescription to Redefine Professional Success, published in 2015 in the George Washington Law Review. They said, simply stated, there's nothing in these data to suggest that attorneys differ from other people with regard to their prerequisites for feeling good. Lawyers and their teachers and employers should banish any notion that law-trained people are somehow special. In order to thrive, we need the same authenticity, autonomy, close relationships, supportive teaching and supervision that promote thriving in others. It's hard to let go of the idea that we're special. And for those of you who are wrestling with it, remember, you'll always be special to those who love you. And while not being special, and not being special doesn't mean that you're insignificant or even ordinary. Fortuitously, just before Carley introduced me to this radical thought by Schreiber and Sheldon, the Saturday paper published a piece provocatively entitled, "What Counts as Rich Now?" written by Mike Seacombe. Seacombe quoted from research conducted by MLC last year, which found that most Australians don't think that $180,000, the level at which the top marginal tax rate kicks in, makes you rich. According to the MLC survey, 50% of the respondents thought that a household needed an income of $150,000 to live comfortably. And more arrestingly, the MLC research showed that the more people earned, the more they wanted. 33% of people earning between $40,000 and $69,000 wanted more. 45% of those earning between $70,000 and $99,000 wanted more. 55% of those earning between $100,000 and $149,000 wanted more, and a staggering 71% of those earning over $150,000 wanted more. Let me illustrate that by reference to some other research.
So what we did is we put two capuchin monkeys side by side. Again, these animals, they live in a group, they know each other, we take them out of the group, put them in a test chamber. And there's a very simple task that they need to do. And if you give both of them cucumber for the task, the two monkeys side by side, they're perfectly willing to do this 25 times in a row. So cucumber, even though it's really only water in my opinion, but cucumber is perfectly fine for them. Now if you give the partner grapes, the food preferences of my capuchin monkeys correspond exactly with the prices in the supermarket. And so if you give them grapes, that's a far better food, then you create inequity between them. So that's the experiment we did. Recently, we videotaped it with new monkeys who had never done the task, thinking that maybe they would have a stronger reaction, and that turned out to be right. The one on the left is the monkey who gets cucumber. The one on the right is the one who gets grapes. The one who gets cucumber, note that the first piece of cucumber is perfectly fine. The first piece she eats. Then she sees the other one get a grape, and you will see what happens. So she gives a rock to us, that's the task. And we give her a piece of cucumber, and she eats it. The other one needs to give a rock to us. And that's what she does. And she gets a grape. And she eats it. The other one sees that. She gives a rock to us now, gets again cucumber. She tests her rock now against the wall. She needs to give it to us. And she gets cucumber again. So this is basically the Wall Street protest that you see here.
Seacombe also relied on the work of Professor Roger Wilkins, who's the economics professor at Melbourne University and the Deputy Director of Research for the Hilda Survey, and Dr. Jill Shepherd from the ANU School of Politics and International Relations. For those of you who haven't been introduced to the Hilda Survey, Hilda stands for Household Income and Labour Dynamics in Australia, and it's been following the lives of more than 17,000 Australians every year since 2001. The survey collects information on many aspects of life in Australia, including household and family relationships, income and employment, health and education. According to the Hilda Survey, middle-income earners earn between $40,000 and $80,000 a year. Annual earnings of $94,000 put you in the top 10%, but that top 10% covers a very wide range of incomes. By the time you're earning $237,000, you've hit the top 1%, and by the time you've made just over $600,000, you're in the top 0.1%. But remember, and that top 0.1%, are also Australia's richest people, the richest of whom, according to the Forbes 2016 ranking, was worth $8.8 billion last year. You have to fall to number 28 on the list to get below the $1 billion mark. So the thesis of these researchers is that if you're a middle-income earner, you tend to mix with people at work and socially who are in the same income bracket. However, once you hit the top 10%, you tend to work and mix with people in that top 10%, but whose incomes could be multiples of yours. Thus, the relative sense of what you need to be comfortable is calibrated not by your own income, but by the higher incomes of those around you. Hence, the clip that you've just seen. That is why people in the top 10% of earners report feeling poorer than they are, or I'd actually say less contented. A week after Mike Seagham's article was published, The Age reported on a report called Happy Workers, How Satisfied Are Australians at Work, written by researchers from Curtin University Business School and based on analysis of Hilda data. And the results are startling, certainly to those who, like me, have grown up in a legal culture where diligence and commitment are all too frequently measured by the reference to the number of hours worked, and where there is often a direct correlation between income, career advancement, and hours worked, and where success is all too often measured by those same standards. The Happy Workers survey revealed that people who worked more than 40 hours a week were much less happy than those who worked 40 hours or less. Or, put another way, working longer hours might help make you more successful by those measures that I've identified, but it's also much more likely to make you really miserable. What the Curtin University study revealed made people happy in their work was first to do work that was meaningful to them, then to have a level of freedom and autonomy in their work, and then to have supportive colleagues and bosses. And these findings replicate the advice given by everyone I've ever heard present to lawyers about well-being. It also replicates, interestingly, the results of our recent court staff satisfaction survey. Court staff are generally not highly paid compared to their private sector colleagues, particularly the young lawyers working as associates in the courts. But they report high levels of work satisfaction because they believe their work is meaningful and they find the environment supportive. It's worth thinking carefully, too, about these other conclusions from the Happy Workers study. People who work for themselves or in small businesses, in the not-for-profit or government sector, and who can do some of their work from home, are more likely to be satisfied in their jobs. And for these happy people, pay was far from being the defining measure of their happiness. In fact, when people were ranking on the ascending scale of very satisfied with their job or satisfied with their job, those who ranked on the very satisfied overall earned a lower average amount than those who reported being satisfied. So what does that mean for us as lawyers and human beings too? I want to pose some questions for you to ponder. How do you define and value success? Is your work meaningful to you? What hours would you like to work? Do you need to work the hours you do to do your job well? How much do you want or need to earn to be comfortable? How much stock do you place on working with people you like or whose values you share? Do you feel valued in the work you do? Do you need to work the way you are at the moment forever? Or can you think of it as a short-term proposition, a springboard to gain experience or financial security to enable you to do something else? Do you understand and accept the sacrifices that you'll have to make if you want or need to work longer hours in order to achieve your goals? Or do you understand and accept the sacrifices you will have to make if you want to work fewer hours or for less money? Apart from your work, what else do you want to do with your life? Who and what outside work is important to you? Do you spend quality time with people outside work who are important to you? How would you describe yourself now? How would you want to be described in 10 or 20 years' time? And the longer term question, what would you have liked to have achieved in your lifetime? There are no right answers to any of these questions, and the answer for each individual will be different. What's important is to ask the questions, to think about what's meaningful to you, and to accept the autonomy that you have to make decisions about the way you want to work and the way you want to live. So I want to challenge the notion that we lawyers are special, different, and destined to suffer higher levels of depression, anxiety, and other mental illnesses than other professions or the population at large, because of the nature of the personalities that make us good at what we do or the nature of our work. Remember, as Professors Schreiber and Sheldon concluded, we have the same human needs as the rest of the population when it comes to authenticity, autonomy, close relationships, supportive teaching, and the supervision that promote thriving. The CV that was used to promote this talk is an illustration, and maybe in reverse of the point that the questions that I've posed. That is the CV that was in the published materials, not the official one that I sent to Will and that he read out to you. And it also poses, in a way, as a confession that I'm still a long way from achieving my goals of being a lawyer and a human too. The other CV wasn't written by me. I wouldn't have dreamt of writing one as frivolous or as personal. And I didn't send it to the people, the working group who organised this talk and have been so wonderful in dealing with me. They found it and asked if they could use it. Its origin is this. Some years ago, I accepted an invitation to appear on Q&A. When I accepted, the producers asked me to send a CV. I did. They rang back. They wanted something funny. I couldn't think of anything. They said they needed it for the audience warm-up. That was a bit of a shock too. They may have said, or at least implied, that nobody could be as boringly lawyerish as my official CV implied. So I told them a couple of things about myself. They then wrote it up, and that was their attempt to humanise me. I'd forgotten about it until it was found and promoted for this talk. Clearly, those who organised this talk also realised I needed to be reminded that I needed to be humanised. So thank you. It was a very important lesson for me. So it brings me back to my starting thesis. No matter how objective we have to be as practising lawyers representing the interests of others, or as impartial as we must be as judges applying equal justice to all, being a lawyer is just part of who we are. We don't stop being a human being when we go to work because of those requirements of objectivity or impartiality. But it is very difficult merging being a lawyer with one's whole self, the other parts of one's life. It's much easier keeping them separate. And let me finish with a confession. I love going to the opera. I love the music, the soaring voices, the costumes, the sets, the productions. I used to love that sense of being swept away into an entirely different and imaginary world. But then, as I tried to merge my different selves, not leaving my lawyer hat at work and my human hat at home, I started to think about the stories, looking at them with my 21st century, first world, feminist, human rights lawyer perspective. And it's ruined opera for me. For years, I've not been able to see Madame Butterfly without thinking that had the Hague Convention on the Rights of the Child and the Child Support Act been in existence, Pinkerton would have had to have paid child support to Butterfly and the baby. They wouldn't have had to live in poverty, and he wouldn't have been able to take the baby away from her. And in more recent years, I haven't been able to watch it without thinking of Pinkerton as a pedophile. Butterfly was only 14 years of age when he purchased her, and she was tricked into believing that she was married to him. I can no longer see Carmen as a tragic story of a man driven to madness by the love of a capricious woman. Carmen was entitled to have relationships with whom she wanted, when she wanted, and to bring them to an end when she wanted, without having to lose her life because of the jealous rage of a former lover who would not accept her autonomy. Now, when I watch Carmen, it reminds me of why I'm proud that the recommendations of the Law Reform Commission, of which I was a member, to abolish provocation as a defence were adopted and passed into law. Tell you, it ruins things. Let me finish with Lucia de Lammermoor. She could have lived a long, happy and sane life with the man she loved, probably would have had many babies with him, instead of descending into agonising mental illness by being forced to marry a man she didn't love to satisfy her brother's dynastic aspirations. Had the Married Women's Property Act been in existence, and had she been able to get a family violence intervention order against her brother and would-be husband. And so it goes on. As you see, it's a journey. I'm not there yet, but I am trying, and you can too.
Good evening, everybody. My name is Marc Huntington. I'm a partner at DLA Piper, practising in the finance and projects team. And can I offer you, on behalf of the partners and the staff at this firm, a very warm welcome. Thank you for coming. Firstly, I'd like to thank you, Your Honour, for an excellent, provocative, appropriately funny address, providing us with insights into the multi-dimensional complexity of your role as a county court judge, and also as a human being. Lest you be thinking that barristers and judges have got a monopoly on OCD, I can assure you the rivers run deep with practising solicitors in OCD. Thank you also for reminding everybody, without exception in this room, that they are special. I'm confident saying that's never been said from behind this lectern before. After 30 years in the law, it seems to me that there are at least two highly prized qualities of being a judge. One is humanitarian, and I think one is to care about the society of which you are a part of. And, Your Honour, I think you've demonstrated that you possess those in spades, so thank you. The Tristan Jepson Memorial Foundation is indeed a foundation very close to our hearts. As Philippa said earlier, Melinda Upton, who is the co-country managing partner of this firm, is a board member. And I also want to say that from a personal point of view, it's a foundation very close to my heart on a personal level. And just for context, before we get into questions and answers, I did want to share something with you that about in 2004, November 2004, I've been a practising lawyer for about nearly 20 years, a partner of this firm for 10 years. I was the leader of a team of 30 people. I was on the national board, and I had a breakdown. And I didn't see it coming. I was subsequently diagnosed with profound clinical depression, and I didn't work for almost 3 years before I found a combination of medication and therapy that worked for me. In 2014, the anniversary of the breakdown, I decided that I'd give a talk to the firm during Mental Health Month, which I did. So I spoke to most of these seats were taken up on a day in November 2014. It was the hardest thing I've ever done. I said a lot of things about it and what happened to me, and from that point onwards, I've had a steady stream, I have to say, of people knocking on my door. Sometimes it's open, sometimes it's closed. But the first person that came in said to me, "Thank you for doing that. You're really lucky my brother didn't make it." So there are many experiences, and I won't dwell on that to take up time, but what I did want to say was that I am still here. I am still doing what I love, practising law, helping people solve their problems. and I have a much more balanced life for it. And I think in that talk in 2014, I stripped it down to 15 or 20 things, and somebody in the audience asked me, well, what can you suggest for us? What would you do differently, was the other way it was put. And I said I'd follow the advice I've just given. So, without any further ado, part of my role is to field any questions or hear any observations or comments that people in the audience wish to make or ask. I'm sure Her Honour is happy to respond if it's appropriate, but we have some microphones roving around, I think.
Judge Havel, you're involved in the Judicial Resilience Program in the County Court, and I'd just be interested to know whether in the course of that program you came across anything that surprised you in respect to people's attitudes to legal practice or their judicial practice themselves.
To answer, because the program involved having individual judges matched with a practitioner, and we were very conscious at the start of the pilot in ensuring confidentiality. Interestingly, we had 20 judges involved in the pilot. By the end of it, I think all of them had outed themselves as being in it. So people were talking about going to see the psychologist or psychiatrist they'd been matched with and some of the things they were discussing. I think one of the things that came out in sort of general discussions that I was involved in, but also came out in the evaluation report that the ever-present Carley Schreiber did for us, was that sense that whilst we had initially thought that the supervision or the resilience sessions would be more about dealing with the work-related issues, you couldn't separate the self from the work. And, you know, even we judges sometimes have to acknowledge we're human. We have families, we have children, we have other commitments, and they impinge on our working career. If people have elderly parents who are suddenly struggling, that's going to affect your life and your work. If you're having a marriage breakdown or your children are causing you trouble, you can't keep that separate from your work. If you're thinking about your own health or your mortality, that's also going to affect the way you approach your work and the way you feel about your work. So it was the understanding that we couldn't sort of say, this is about work, and anything that's personal, see your own practitioner. It didn't work that way, and so it was part of that learning about, again, the whole self, not leaving your personal life behind. I think that sort of idea that as a judge we have to be impartial had sort of infected some of the thinking, so there was a real concern about whether we were detached from life, and some of those symptoms I described that attached to vicarious trauma were that too. One of the ways of coping with a constant flow of distressing work is to detach, but emotional detachment can be a very dangerous thing. So they were the main learnings, you know, not separating the personal from the professional, understanding of the way you are as a person links in. And the sort of liberating effect of starting to talk about it as a normal thing to do and a really important thing to do. So we were so worried initially that people wouldn't want to have it talked about for fear it would be seen as you're suffering, you're sick. We really were very conscious of saying this is not about people not coping. This is about learning to recognise why these things are hard and how to better manage them. And so it was a much more positive thing, and people really benefited, I think, from talking about that and helping frame it that way. But you know, we started talking about debriefing. We wondered whether we could call it counselling. We talked about resilience. We're now calling it a reflective practice program. So there's been a real progression for us in trying to understand what it is and what we're trying to do. And it will continue to change, I think, as we learn more and see what people's needs are.
Hello, Judge Hampel. Thank you very much for a very human talk. I was interested in what you were saying about, I suppose, lawyers not being special, because I thought perhaps there were certain personality types or tendencies in the law that made us more prone to suffering from mental illness. But I was wondering perhaps if you could comment more on whether there may be instead structural issues in the law and in our industry that might tend towards that. For example, you mentioned long hours equating to success, so perhaps moving away from billable units or anything in that respect.
That study, the Happy Worker study, produced a fantastic chart that shows people working up to about 20 hours have, report gradually ascending levels of happiness. And then from about 20 to 40 hours, it's pretty uniformly high. It gets a bit higher, peaks up at 40, and it goes down like that after 40, almost straight down to 50 and then tailing even further down when people work 60 hours or more. It is really arresting because I think, and I was trying to sort of tease this out as I was preparing for this talk, we have for a long time measured success by hours worked. I worked 20 hours. I worked all weekend. It's almost as, getting into the club. And I've never worked in a big firm, and I've never had to live in the very short time I was a solicitor with billable hours. So I'm conscious of the fact that I don't know enough about it to be able to comment in a properly informed way. What I read suggests that targets are often very difficult for people to meet, and that billable hour targets, and that encourages longer hours. I would like to really, I'd like to see a shift in thinking about how you measure the quality of work. Personally, I've always had a difficulty with measuring it by the number of hours put into something that can have a built-in inefficiency factor. Maybe ways of finding different ways of costing particular work could be a way of doing it. But because I've never worked in a big firm and I don't understand their pricing structures, I've shied well away from doing it. What I do want to really make a point about is if it's very clear that once you get beyond 40 hours a week, people aren't happy and they may not be as productive either, then I think that should bring about a shift in the way places or firms structure themselves. But that might mean less pay for people who are in fact going to work a 40-hour week, not a really big pay packet with no notional work hours, but an assumption or expectation that it could be an 80-hour week. There have been a lot of studies done in the medical profession about how unproductive people become after they've worked a certain number of hours, how they're equating, tired young doctors who are working 75 hours or more a week, have levels of delayed reaction similar to people who are driving with a blood alcohol level of 0.1 or over. Means impaired decision making, impaired judgment. And I think that works for lawyers too, because we're working with our heads and our thinking. France's experiment of having a 38-hour week, so to try and give people work-life balance and give more people work, so far has been an abject failure as far as I can work out, because people cut down their working hours, but employers or government don't necessarily employ more people. But I do think sort of some more creative thinking about job flexibility, about sharing work between people, so that the expectation is not 6-hour days or 80-hour weeks, that's unrealistic and unproductive to ask of people. Paying people less but demanding fewer hours of them and sharing the work amongst more people is actually a much more interesting way to start thinking about doing it. But I'm really conscious of the fact that I can't presume to lecture to people who run what are businesses. Law firms, whether they're little or big, are businesses. We, as lawyers, are and should describe ourselves as professionals. But the law practice is a business. And so working at how the business can properly cost itself, but how to value people as people, not as widgets or units of production, I think is one of the really important parts of that. I get really upset when I read reports that talk about numbers of people in workplaces and they're all described as FTEs, full-time equivalents. You know, that to me is a hugely depersonalising term. I know you can't say, you know, Peter, Sue, Katie, and, you know, list the individuals in a particular work group, but I do think that sense of the individuals rather than the FTEs or the level 2s, level 5s, you know, VPS 6s or whatever, has to be acknowledged for what it is, a depersonalising factor. Maybe less profit, but you know, I don't know.
I think we have time for one more question.
Thank you, Judge Hampel, for your wonderful keynote. My question is an extension of the previous question, but in regards to law schools, and how can we encourage reflexivity and normalising the discussion regarding taking care of yourself and having good practices which will enable students to come into the workforce with the skills they need?
One of the wonderful things that has been introduced to judges through the Judicial College of Victoria has been the introduction to mindfulness practice. And one of the practitioners who has come to work with us to describe mindfulness and to take us through mindfulness exercises is Dr. Craig Hassad, who is a doctor and an academic teaching in the Monash Medical School. It's a loop, but I'm getting there to answer your question. At Monash Medical School, they teach mindfulness as part of the curriculum to medical students, partly for patient care, but partly for self-care. And I think it's a very interesting model that law schools could think about. Tucked into my talk was a criticism about law school teaching or lawyers coming out of law school and into practice not having any respect for the learnings from social sciences. I think we need to be much more cross-disciplinary to understand there's a lot to learn from other disciplines, but to embed in legal teaching and in law schools turning out people for the future about the self-care, about the awareness of what, you know, has often been disparagingly called the soft skills. But as part of almost every course or every subject, there should be a learning about and a commitment to thinking about how this person is going to be when they finish, whether they're going to be a practicing lawyer or whether they're going to do something else with that wonderful legal training, but thinking about understanding more about themselves and their role in an early stage of their career and in practice. It's a very uncertain time for a lot of law students. Employment's difficult. The whole legal market is changing. The way people practice law in 10 years' time, I think, will be very different from the way it's practiced now. And so equipping people with these more flexible skills, I think, is as much a priority for law schools as teaching the Priestley Nine. In fact, I think we probably need to revisit them too, given our modern law schools. Someone told me the Priestley Nine were devised before the internet really came online. Think about that.
Thank you, Judge. I would say that you've missed nothing if you haven't had billable units. Nothing at all. And right now I'm 0.7 FTE, so I'm even a lesser person. But still here. To conclude the formal part of this evening, can I introduce Murray Jepson, who's the co-founder and director of the Tristan Jepson Memorial Foundation. Thank you.
Good evening. In the interest of full disclosure, I have to tell you I'm not a lawyer, so I'm going to say probably that I'm the person responsible for saying that's not a human CV. We've got to find something else about this judge. So I'm sorry about that. For me, this evening has been astounding because I never thought I'd live long enough to hear some of the things I've heard. And it's extraordinarily exciting to have Marc talk about his experiences, to hear what the court has been doing, permission to think differently. It's to say this is an ongoing learning process, we haven't got it all right, is huge. And from when I started, it's amazing. So thank you very much. So let me start. On behalf of the Tristan Jepson Memorial Foundation, or TJMF as we're usually called, and myself personally, I'd like to thank Her Honour Judge Hampel for being a keynote speaker this evening. As a prominent leader in the profession, you lead by example. The comments you've made today, I haven't heard in all my years, so thank you. But also as an encouragement to others. In October 2014, the County Court created the Supporting Judicial Resilience Program as a 6-month pilot to support wellbeing of County Court judges, especially in terms of exposure to vicarious trauma. And following an independent evaluation, the program is now available to all County Court judges. What a wonderful thing and legacy. And in 2015, in her article in the Law Institute Journal, Her Honour commented, increasingly there's a recognition that work at the bench takes its toll, and it's not a sign of weakness or unfitness for the job to acknowledge it. 20 years ago, this conversation would not have been taking place. It wasn't taking place 15 years ago. There's an overwhelming need to introduce preventative measures as well as programs and structures to support and enhance the ability of judges to shoulder the responsibilities and enjoy the intellectual and other rewards of judicial life. And although focused on the judiciary, these words hold true for the entire legal profession. I'd also like to thank the President of the Australian Bar Association, Mr. Will Alstergren QC, for his welcoming remarks, and DLA Piper for hosting the lecture, and the staff who've managed the logistics, as well as Michael McGarvey and the Victorian Legal Services Board. And I'd like to acknowledge the services of the many who have done all the tasks to get this evening organised. However, the true unrecognised heroes who've made this lecture possible are 3 young Melbourne lawyers, Arandothy, Pip and Max, and there are simply no words to express my enormous respect, gratitude and thanks for all your efforts and the support given by your partners and families. The Foundation aims to decrease the disability and distress of mental ill health in the legal profession and promote a psychologically safe and healthy workplace. 3 years ago, we released the voluntary Workplace Wellbeing Best Practice Guidelines. They're evidence-based and focus on the prevention of harm and psychological injury in the workplace. They provide a management framework to support leaders to create and sustain a safe and healthy workplace through an ongoing process of improvement. They are not a mental health program. And we are proud that we have more than 170 national and international legal workplaces that have become signatories. And among these, Victoria is very well represented with the Supreme Court of Victoria, the Australian Federal Court, the Victorian Bar, the LIV, the Wattle Foundation, and many organisations. And we're also delighted that the guidelines have crossed the professional boundaries to include the medical profession and can count the Australian Medical Association Queensland, Children's Health Queensland, and recently Monash Health among our signatories. However, there's a major barrier to the successful implementation of the guidelines in workplaces. The perception that mental health is the new black, and that the guidelines are just another mental health program which addresses the problem, hinders their successful implementation. The guidelines are not about mental health. They're about engaging staff. They're talking about all the factors that Her Honour talked about. They're about creating a psychologically safe and healthy work environment which supports and enables everyone to perform at their best. They are simply good management. We need to change the conversation which focuses on the negative, you are a problem, and recognise that we are all human and share a common vulnerability. When our well-being suffers, we don't perform at our best. At some time in our life, most of us will face challenges that impact our well-being. And when well-being suffers, we don't perform at our best and may struggle to carry out our professional duties. Admitting you are struggling feels like you're saying you can't do it and you don't belong to the profession. And this leaves too many people isolated and under unbearable stress. It's time to recognise that these pressures exist for everyone, and there are steps we can take to manage them. No longer is it good enough to say that the law requires survival of the fittest. All lawyers should be supported to get help to be the best they can be. And pleading sanity that Pip talked about earlier, sane forums that are available via the TJMF website, employee assistance programs, programs through the LIV. There are many support opportunities as well as going to see your GP. As Associate Professor Mamta Gautam commented in the 2006 inaugural TJMF lecture, the very qualities that make us good lawyers make us vulnerable to mental ill health. And these qualities, though highly desirable professionally, are extremely costly personally. Overwhelming evidence highlights the impact of this cost not only on individuals, their families and society, but also on workplaces. This is evident in the increasing direct costs of stress-related claims and skyrocketing insurance premiums. In addition, there's a declining morale in a culture which permits bullying and inappropriate behaviour to thrive, and where there is fear of retribution for speaking up. Quite simply, the profession needs to recognise that people are your business. Each workplace relies on the personal intellectual property or capability of your people to think clearly and make good decisions. We all perform better if our strengths are valued rather than having our flaws highlighted. Given the profession's focus on sustainability, keep in mind that lawyers see themselves as peak performers, much like racehorses or elite cars. However, racehorses don't thrive on neglect or being left out in the paddock. In order to sustain their peak performance, racehorses require far greater care and investment. They simply don't perform at their best if the conditions are not optimal. Similarly, as lawyers, we need to look after ourselves and each other. In order to engage their staff, leaders need to value the contribution each individual makes to the team as well as to their organisation's business outcomes. The role of a leader is like that of a conductor of an orchestra. Not every musician is able nor strives to be the first violinist, but all contribute and play a vital role in the success of the ultimate performance. And in closing, I'd just like to leave you with a story of starfish. While walking along a beach, an elderly gentleman saw someone in the distance bending down, picking something up and throwing it into the ocean. As he got closer, he noticed that the figure was that of a young man, picking up starfish one by one and tossing each one gently back into the water. He came closer still and called out, "Good morning. May I ask what it is that you are doing?" And the young man paused, looked up and replied, throwing starfish into the ocean. And the old man smiled and said, well, I have to ask you, why are you throwing starfish into the ocean? And to this, the young man replied, the sun is up and the tide is going out. If I don't throw them in, they'll die. And upon hearing this, the elderly observer commented, but young man, do you not realise there are miles and miles of beach and there are starfish all along every mile? You can't possibly make a difference. And the young man listened politely, then he bent down, picked up another starfish, threw it back into the ocean, past the breaking waves and said, it made a difference for that one. Thank you.
That concludes the formal part of tonight's proceedings. We'd be grateful if you would come and join us for a drink outside.